There we go. All right, we'll get started again. As a reminder to those virtually, I think we got this CLE code problem fixed, and so it should be in the chat box. The next panel will be Innovation and Winding Up Proceedings of SMEs. Dr. Shuai will lead the panel. He is also one of our executive committee members, along with Harold Fu, Yuri Sugano, and Dr. Wesley Rosslyn-Smith. So I'll hand it over now to the panel.
Thank you, Evan. It's the slide. Next page. Good morning and afternoon, maybe evening for people from all over the world. It's our great pleasure to be here today to discuss innovation in winding up proceedings of SMEs. For today's session, we will break it into 3 parts mainly. In the first maybe 20 minutes, we will discuss our separate jurisdictions rules on SME winding up proceedings. And then we will have a group discussion and several questions we found very interesting. And for the last part, we welcome questions from all the audience and we'll answer them. And next slide. First of all, please allow me to briefly introduce our panelists. I will start with the sequence, Mr. Harold Fu, who is Assistant Director in the Policy Advisory Division at the Ministry of Law of the Republic of Singapore. He has been closely involved in debt restructuring, insolvency policy development, and legislative reform, including Insolvency, Restructuring, and Dissolution Act, Singapore's omnibus insolvency legislation. At the international level, Mr. Fu has been a member of the Singapore delegation to Ancestral Working Group 5 since 2017. He was actively involved in the negotiations and completion of ancestral model law on recognition enforcement of insolvency-related judgments and ancestral model law on enterprise group insolvency. Mr. Fu was elected chair of the working group at its 56th session in December 2019, leading the deliberations, finalization, legislative recommendations on insolvency of micro and small enterprises. He was also elected vice chair of the Ancestral Commission at its 54th session in July 2021, overseeing the adoption of legislative recommendations by Ancestral. Prior to joining the Singapore Legal Service, Mr. Fu was a member of the debt restructuring and insolvency team at one of Singapore's largest law firms. And for the next speaker, I will introduce Ms. Yuri Sugano, who is a partner of the Insolvency and Restructuring Group at Nishimura Asahi, which is the largest in restructuring insolvency practice in Japan, with about 50 highly specialized attorneys who provide first-class services for all types of restructuring and insolvency cases. One of her strengths is that she usually simultaneously handles not only large cross-border restructuring cases, but also domestic SMEs restructuring cases. As an example of her work, she represented a counterfiling of civil rehabilitation proceedings against the existing bankruptcy of Mitgosks in 2018. In addition, she was appointed a deputy trustee in a corporate restructuring proceedings for a mid-sized Japanese shipbuilding company in Tohoku region, the area which was most affected by the March 11th triple disaster in 2020. Moreover, she is actively involved in a number of professional associations regarding cross-border restructuring. More precisely, she serves as Asian Advisory Council and a co-chair of Japan Region IWORK. And for our next speaker is Dr. Wesley Rosslyn-Smith, who is a corporate and turnaround strategist who works with distressed organizations to diagnose and recover. He currently resides as a senior lecturer at the University of Pretoria within the Department of Business Management. He lectures within disciplines of strategic management, business analytics, and business turnaround. He has developed several courses in business analytics and is deeply concentrated on the future work and a broad range of contemporary organizational issues. He holds a PhD in business management from the University of Pretoria. And for myself, I'm now currently an assistant professor at China University of Political Science and Law in Beijing. I hold a PhD from Leiden University in the Netherlands. And I'm also sitting on the executive committee of NextGen, starting from earlier this year. For the moment, I'm currently working on the Asian Business Law Institute project, Asian Principles for Corporate Structuring, and at this moment on SMEs. So this is the topic we are going to talk about today. And next slide, I will start with China. So in China, there is almost no special provisions at SMEs in our bankruptcy law. We only have regularization, compromise, and liquidation, which are the main and normal proceedings. However, our Supreme Court has special rules that guide lower courts, including the 2018 legislation that is the record of meeting the national court's bankruptcy trials, and 2020 opinions are promoting efficient trials of bankruptcy cases. Simply put, if the case is with the relationship between creditors and debtors clear and there's a financial status clear, there are some simplified procedures for these cases, normally SMEs. And next slide, please. I made a comparison between those simplified proceedings and normal proceedings. First of all, there's no time limit for normal proceedings, but usually for SMEs and so for those simplified proceedings, there are less than 6 months requirement. And starting from the filing a bankruptcy case to the court to notification of creditors, usually it takes about 25 days, but for SMEs, it's 15 days. Also, the decision-making process from the filing of administrator's final report to the court to its final decision is 15 days in normal proceedings, but 10 days for SMEs and simplified procedures. Also, there are other simplified procedures such as voting, for example. In normal proceedings, if you do not agree on the previous plan, you need another round of voting, but for simplified procedures, there could be different plans proposed at one meeting, and for creditors to vote on both of them if plan A do not go through, and then it goes through directly to plan B. That saves some time. And lastly, then there's an investigation period for insolvent practitioners that is set as 30 days that will make sure the procedures will be finished within a certain period of time. I think those are the general provisions in China that mostly procedures are simplified. I will hand the floor to Harold, and next slide.
Thank you, Shuai, and thank you for the introduction. I also like to take the opportunity to thank the organizers for the program as well as the admin arrangements. So just to provide some context on the Singapore discussion, the smaller businesses in Singapore make up a significant proportion of the economy, and this is approximately 95%. And so we have seen in recent years a shift to provide some innovations to tailor processes to the smaller businesses. And in my short segment, I'll touch on two key innovations that are applicable to SMEs. On this first slide, the first innovation relates to a summary liquidation procedure, which was introduced last year in 2020, that while it applies to all companies, it's particularly useful for SMEs. And this is an early dissolution process where in cases where the company is hopelessly insolvent and it may not even be able to cover the expenses of winding up. And so there are two conditions before this process may be triggered. First, the company has insufficient assets to make any distribution to creditors. And second, no further investigation is necessary in the winding up process. And with these two conditions fulfilled, notice may be given generally, and if no objections are received, after 30 days, the company will be struck off. So this is the first innovation that we have. And the second critical innovation, which I will touch on in the next slide, is in response to the COVID-19 pandemic. And Singapore introduced a temporary simplified insolvency program for micro and small enterprises in financial distress. And this temporary program encompasses both simplified debt restructuring as well as simplified winding up. And given the topic of this panel, I'll focus on the latter. Just briefly, this process is adapted from the creditor's voluntary winding up process, and therefore this removes the necessity, cost, as well as time for court that is necessary required in a normal court application to place the company into winding up. With this new process, this court application is no longer necessary, and therefore increases the time and efficiency taken in such proceedings. Some further innovations include the rescope functions of the liquidator, given the profile of these companies, reducing some of the more complex and costly aspects such as creditors meeting and commencing legal actions. And last of all, the target for this is about 90 days. So just to give an idea of what the standard timeline for these early dissolution, temporary simplified winding up processes would take. And with that, I will turn the floor now over to Yuri or Wesley. Wesley, sorry.
Thanks, Harold. Okay, so similar to Singapore, but just slightly higher, South Africa's SMEs make up about 98.5% of businesses in the country and are a critical force in the country's economy. They play a big role in addressing the major challenges of unemployment, inequality, and so forth. However, they face a devastating odds, with 5 out of 7 of these businesses failing within the first year, resulting in one of the highest failure rates globally. And that's why I want to give a little bit more context to the environment SMEs face in order to tackle the topic at hand. Coming into COVID-19 crisis, small enterprises in the country were already facing significant headwinds. A sluggish economy coupled with several rating downgrades have negatively affected SMEs year on year. During a global financial crisis in 2008, the SMEs bore the brunt of job losses and revenue declines. Now, the ongoing COVID-19 crisis has had devastating impact on our SMEs as well. Stringent lockdown measures imposed early on caused consumer spending to dry up, revenues to fall, and almost overnight threatening the livelihoods of an estimated 60% of businesses. And while conditions have since eased, many SMEs remain vulnerable. Analysts predict that around about 60% of our SMEs may close before the crisis is over. This situation has obviously highlighted the long-standing issues on how we handle SMEs, in particular, how they fail. Next slide. But what is an SME in our context, right? Does it include the local bakery, wine farm, or does it also include the local spaza shop, as we call them? And I think it's very befitting that I quote the former president when he said that in this context, it is observed that our country is characterized by 2 parallel economies, the first and the second. The first economy is modern and produces the bulk of the country's wealth and is integrated within the global economy, while the second economy, or the marginalized economy, is characterized by unemployment and contributes little to the GDP, contains a big percentage of our population, incorporates the poorest of our rural and urban poor, is structurally disconnected from the first and the global economy, and is incapable of self-generated growth or development. And so when scrutinizing the SME landscape in South Africa, one must account for the variety of both formal and informal ventures that require assistance in distress in different forms. Innovative winding up procedures must account for these distinct differences to avoid abuse and to make meaningful change to our entrepreneurial activity. Next slide. So our latest research places high expectations in the country, one of Africa's 2 largest economies, where remarkable strides have been made against poverty in the past 2 decades, have been stalling. South Africa's ability to regain momentum has implications for the continent as a whole. While South Africa's unemployment sits at around about 34.4% this year, there are grounds for optimism and new avenues for growth. Characterized as an efficiency-driven economy, where the support and relevance of government policies are more likely to boost entrepreneurship than innovation than in innovative-driven economies. This encourages the need for insolvency reforms to aid our small business recoveries and also winding down. Now, a good barometer to gauge the impact of insolvency procedures on entrepreneurial activity is the rate of fear of failure. This is the percentage of the population perceiving good opportunities who indicate that the fear of failure would prevent them from starting a business. The readings on the fear of failure are lower in factor-driven and efficiency economies like South Africa than with innovative economies, with around about 1/3 of the working age adult population indicating that they'll have a fear of failure. Just for interest, that in 2018 GEM report indicated that the fear of failure in China was around about 41.5%, South Africa 31.3%, and Japan was actually 41.2%. Unfortunately, Harold, I couldn't find any figure for Singapore. Next slide. Next slide, thanks. Okay, so no comprehensive and focused process of dealing with financially distressed small businesses exists in South Africa, similar to what Shuai said around China. Whilst business rescue, which is our formal reorganization procedure, remains the most viable formal insolvency mechanism available to SMEs in South Africa, it is often too expensive to implement or remains elusive to small business owners. The effect thereof is that few SMEs use the procedure and are instead left to defend themselves without any formal insolvency protection. While a recent local report has highlighted the need to introduce special SME provisions to business rescue, this has yet to happen, despite the globally accepted view that SMEs are a much needed panacea to promote economic development. The lack of innovation in winding up or reorganizing SMEs has certainly hindered our post-COVID recovery. And that's me. Thanks. I hand over to Yuri now for a perspective from Japan.
Thank you, Wesley. Okay, thank you. I just check the chat. So thank you, Wesley. So I, Yuri Sugano, would like to explain innovations in winding up proceedings of SMEs in Japan. Similar to Singapore and South Africa, the Japanese economy is also heavily reliant on SMEs. More precisely, 99.7% of all corporations are SMEs, and SMEs employ 68.8% of all employees in Japan. Moreover, although we also do not have any specific liquidation proceedings in place to deal with this issue, we do have a set of guidelines and practical arrangements which allow us to dissolve financially distressed SMEs in a relatively flexible and simplified manner. Let me start by explaining the current environment of SMEs in Japan. Japan is currently facing significant demographic struggles, which has led to a unique problem for SMEs, that is, a lack of successors due to its aging population. This problem has been getting worse and worse on an year-by-year basis. The average age of CEOs in Japan has increased by 8 years over the past 30 years, from 54 years old in 1990 to 62.2 years old in 2019. Furthermore, over 80% of the CEOs of dissolved corporations are more than 60 years old, and amazingly, 40% of them were in their 70s. This phenomenon, together with the economic impact caused by the COVID-19 pandemic, resulted in a record number of liquidations over the past 20 years, with roughly 50,000 cases reported. SMEs liquidations are especially problematic for the Japanese economy, as over 85% of SME owners provide personal guarantees against corporate borrowing. It means that SME liquidations directly affect the well-being of SME owners. Next slide, please. However, the Companies Act in Japan does not specifically address liquidation proceedings for SMEs. On the other hand, alternative measures have been established for winding up SMEs. One of them is called the Special Conciliation Arrangement. Special conciliation arrangements are a conciliation process which is governed by the Act on Special Conciliation Proceedings for expediting arrangement of specified debts. These special conciliation proceedings can be used to facilitate the arrangement of financial debts, including rescheduling, DDS, and discharge of debts. This is also used as a method of supporting the winding up of SMEs, which have difficulty in continuing their businesses due to excessive financial debt. The Japan Federation of Bar Associations, JFBA, issued guidelines in 2018 to assist a fresh start for SME entrepreneurs by creating a protocol which allows for smoothly liquidating their current non-competitive businesses. Special conciliations are more rapid, cost-efficient, and flexible procedure than either bankruptcy or special liquidation proceedings for distressed companies under the Companies Act. In addition, special conciliations can reduce stigma, as this excludes trade creditors and only targets financial institutions. Moreover, special conciliations can integrate the treatment of personal guarantees. Special conciliation can also be used to address the position of the principal debtor and its guarantors simultaneously in order to coordinate arrangements for both sides. So, since Japan is struggling with an aging population, one void of successors for SMEs, and SME owners are liable for corporate failures, it is essential for the SME liquidation procedure to be as efficient as possible. Since it takes a long time to reform and create laws which deal with establishing a new simplified winding up procedures in Japan, we have solved this issue in a more practical manner by implementing existing proceedings with a set of guidelines. I hope our solutions to this issue may be a useful reference for other jurisdictions. So I finished my part. Let me check the time schedule. Okay. So
Yeah, I think it went well. Thank you all. And then we'll enter into a group discussion part. I think the first question is for Harold about international developments. I know you are working with Onshore on the SME project, and how is that going?
Thanks, Shuai. So I think internationally there is increasing recognition of the importance of tailored frameworks for micro and small enterprises, and this is demonstrated by two instruments that was recently concluded this year. One is the UNCITRAL legislative recommendations on the insolvency of micro and small enterprises, and the other would be the World Bank principles on MSE insolvency as well. And both of these developments speak to the economic importance of MSEs to economies. And I think the numbers that we have seen from South Africa, Japan, and Singapore provide a snapshot of this. And also, secondly, the fact that some of the current insolvency regimes are generally designed for larger enterprises in mind and may not be fully tailored for smaller enterprises. And given my involvement in the UNCITRAL side, I can speak to that more easily. And this set of recommendations at its core aim to strike a balance by, on one hand, providing simplified and streamlined processes, and on the other hand, ensuring that they are appropriate and proportionate safeguards. And some of these objectives would not be a surprise to the insolvency practitioners in the room, such as promoting a fresh start, providing effective measures to facilitate participation by creditors, given frequently the presence of creditor apathy, addressing issues of over-stigmatization, which we will deal with later as well, and also to preserve employment and investment. So with these various instruments, these are in addition to the general objectives of insolvency laws in general, and I think they generally demonstrate the importance and growing recognition of the importance of such frameworks.
Thank you very much. Wes and Yuri, do you have any additional comments to this question? No, and then we'll go to the next one. And I think that's related to the topic our today. Why is there an increasing focus on innovation in SME proceedings? And I will give the floor first to Yuri. You just mentioned that over 99% of the enterprise in Japan are SMEs. So maybe that could be a reason why we should focus on this question.
Yes, so that is, of course, one reason. So not only Japan, but also other countries are also heavily reliant on SMEs, and both numbers of corporations and also employment. But I think this time, the reason why an increasing focus on SME liquidation this time is definitely, we can say, because the economic crisis generated by COVID-19 pandemic affect. So that is, I think, the biggest reason now why people are focusing on this issue. So although the outbreak of COVID-19 has impacted almost all industries, some specific industries such as food services, hotel industries, retail shops, and apparel shops have been significantly damaged by the negative impact of COVID-19. These industries are heavily reliant on SMEs, and SMEs are generally more financially unstable. SMEs have been facing more risk of winding up the businesses under the pandemic. On the other hand, many jurisdictions do not have specific insolvency and liquidation framework for SMEs. In these jurisdictions, the traditional insolvency and liquidation proceedings are too costly and complex to be applied for SMEs. Therefore, recently, as Howard said, there have been global discussions regarding the need to implement simplified insolvency and liquidation frameworks for SMEs. So as I explained in my presentation, Japan has already faced increase of numbers of SMEs liquidation due to the lack of successors and then the aging population issue before the COVID-19 crisis. However, I believe that the liquidation framework for SMEs to solve this issue can be utilized for SMEs liquidation caused by COVID-19 pandemic.
Yeah, thank you, Yuri. And any additional comments from Weston and Harold?
Sure,
Wes.
I'll add in there. I think Yuri has really summed it up quite well. Other than the fact that these SMEs make up the bulk of our economies, all of our economies, they're critically important. And for the last decade or two, there's been a growing interest in terms of stimulating economic entrepreneurial activity in countries and assisting SMEs. But if you're going to create mechanisms and you're going to make it easier for entrepreneurs to set up businesses, you have to at the same time create the same sort of ease when it comes to closing those businesses down. And I think that that's been the lacking part until now, is that a lot of economies, a lot of countries haven't modernized their laws around SMEs and how to wind them down, but they've plowed a lot of time and funds into actually setting and trying to stimulate economic entrepreneurial activity. So I think it's just a matter of now playing catch up with those sort of insolvency measures.
Okay, thank you very much. And we'll go to the next question. I think that's related to the perception of common people in the jurisdiction concerning bankruptcy and winding up proceedings for SMEs. For example, how has the stigma associated with insolvency changed over the past few years? I could take the first floor that in China, I think many people are still very reluctant to admit their business go bankrupt. So they will borrow money from maybe family and friends to continue a small business if they can. then going to a court to file for bankruptcy. I think that's still a very elegant way people could do to prevent bankruptcy in a certain way. But starting from, I think, 2019, 2020, there's been a trials for personal bankruptcies in China. Well, a lot of discussion going on about whether this is a way of avoiding debts where people are like losers if they go bankruptcy. But I think the environment has changed a little bit with the promotion and advertisement of this personal bankruptcy and small business bankruptcy. That maybe the stigma associated with bankruptcy is improved a little bit. I hope it will improve in the future. I think that's the first step to solve the SME insolvency problems. And then I will give the floor to Wes.
Great. Okay, so I think, very similar. There is still quite a bit of stigma associated with any sort of insolvency procedure in South Africa, be that a reorganization or liquidation. I think the first and most primary reason is that people perceive it as it contributes to your deepening insolvency situation. So that the fees are very expensive, you lose control, and it kind of just digs the hole a bit deeper. It is a highly creditor-friendly liquidation procedure we still have in place. Although we have a very debtor-friendly or orientated reorganization procedure, on the liquidation side, it's still heavily creditor-friendly. And I think that's also created a lot of hesitation for SMEs or businesses in general to seek liquidation out. And then there's also this limited debt forgiveness that exhibits itself in countries where there has been a long-standing creditor-friendly procedure in place. Going bankrupt in South Africa holds a terrible stigma. It's very difficult to get back onto your feet and to have a fresh start. And I think that is as a huge contributor to this problem. Thanks.
So Shuai, let me now explain this question regarding Japanese situation. So in Japan also, the stigma associated with insolvency proceedings, especially bankruptcy proceedings, had strongly remained among SMEs and especially local areas. This stigma is more serious because, as I explained, most of SME owners in Japan provide personal guarantees against corporate borrowings. The stigma associated with corporate bankruptcy directly connects to the stigma associated with bankruptcy for the SME owners individually. However, Japan has several alternative measures for winding up SME businesses apart from the apart from bankruptcy proceedings. So the special conciliation arrangement is one of them, but also there's another alternative measure. For example, the workout programs under SME Revitalization Support Council are widely used to facilitate the arrangement of financial debts for SMEs over the past few years. So this kind of alternative measures are not in court insolvency proceedings. Therefore, these proceedings can keep confidentiality and exclude trade creditors. So these measures can reduce stigma when the SME owners enter into liquidation.
Thank you, Yuri. Any comments from Harold?
No, I fully agree with everything that what was mentioned, and I think this issue of stigma is a big one across many jurisdictions. And in Singapore, I think that there are two facets to this. One is in the larger enterprises, one of the review committees had mentioned that people have been holding on too long and hoping that the business will turn around, but actually, like what Wesley says, it just deepens the insolvency. So I think that was one key issue, and with the reforms that we have made to make the corporate restructuring regime more robust, and with successful cases of people actually coming out the other side, then that provides a mindset shift for the larger enterprises. And I think with the smaller enterprises, the reforms that we are taking and all of these new frameworks that we are discussing provide a platform for smaller businesses to go through in a quick way without killing off entrepreneurial spirit and without attaching over stigmatization to bankruptcy proceedings. And therefore, while this is a continual process, hopefully the issue will be addressed in a more holistic way in the years to come.
All right, thank you. And we will take the next question. Like, if you were to make one change to jurisdiction solvency regulation to assist SMEs, what would that be? I'll first start with my perception, maybe from academic, that I want to separate proceeding for SMEs rather than normal companies. I think the situation in China may be a little different because China, although there are quite a lot of SMEs, I think it's over 3 million SMEs, but China's economy also rely heavily on large corporations. And just in the past few years, there's large airline companies, banks, football clubs, and that's conglomerates that go bankrupt, and people's and insolvency practitioners focus on those companies. Well, there's also the legislative proposal to reform our bankruptcy laws, and a lot of attention is paid to restructuring process, to pay to listed companies, but not so much on SMEs. I think one of it is that they do not make a lot of money from SME restructurings, and people are a little bit reluctant to go to court if they are just family business or just one-person businesses. I think the one that's related to our previous stigma problem. And also, the payment rate in China is about over 30%, and within this repayment, about 1/3 will go to most services like course fees, attorney fees, other services, accountants, etc. So there's not profit to be made from doing SME business. So that's why I think not so many insolvent practitioners are really going to do that. And that's also in another way means the SMEs will not go to court because they have to pay a lot of fees for that, and maybe they do not have that access to money left for them to pay the court fees and attorney fees. So my idea is that we should, at least in China, there should be some additional public service agencies. I think there are some trials in Shenzhen, the city borders with Hong Kong. Now there's some trials that within the government, but not a court system, there's a government bureaucratic system of bankruptcy proceedings will assist those small and medium enterprises. There may be some public servants that will try to help SMEs to go through those complex and costly procedures. But this is from my academic perspectives. I have talked to some other practitioners in my country and my fellow practitioners. They may not share my opinions. They do not, I not like here to diminish their role in sovereign proceedings, but that's just my thinking. And then I will give the floor to Harold.
Thanks, Shuai. I'm aware that we have one question and short of time. So I think the one thing that I would change has already been put in, which is this new program for micro and small enterprises. And the big issue would be then reviewing it and to see how it works, and also have a look at how other jurisdictions have done it, and to see how we could improve on what we have, which is a temporary program in light of COVID, but hopefully we can have something a bit more permanent.
and Wes and Yuri.
Okay. From a South African perspective, I think the first thing that I would start off with is promote a fresh start for debtors. I think it would have the biggest impact with the most least effort in our jurisdiction. And it's the biggest thing that's lacking in sort of the SME environment.
About Japan, I am mostly satisfied with the current insolvency regulations because we have both in court liquidation proceedings, bankruptcy proceedings, and then also restructuring proceedings. And also we have alternative measures, including the conciliation and also many different type of workout programs. But if I mention one request for the current Japanese regulations, we don't have restructuring proceedings. So in-court restructuring proceeding only for specific for SMEs. So that's my only request.
Okay, thank you all. And in terms of question 5 about how do one proceedings SME apply simplified procedure, we will integrate another question, a fantastic question from Steve. And he raised the question about the possible stock rise in bankruptcies. He mentioned that it is expected that as governments and financial institutions on pandemic era measures that were designed to help businesses, there may be on tick, if not a surge in business bankruptcies. Will the courts in your jurisdiction be able to handle such a possible stock rise in bankruptcies for SMEs if that occurs? I think it's closely related to our question 5 in terms of the way that many of the SME winding ups apply simplified procedures that will reduce the workload of courts. And also from my perspective and my talking to my colleagues in China, I do not think the courts are overloaded. Yes, and I think before the pandemic, there's already been an increase in bankruptcy proceedings because the economic reform here. And they are recruiting more judges, and there are more lawyers entering into the bankruptcy business, and there are special bankruptcy courts set up across the country to focus on bankruptcy proceedings. I think that's how they are handled. Also, I think in our questions that were mentioned, technology applied, and that's also a way to solve the increased amount of cases of bankruptcies, because now during the pandemic, we use hybrid forms that people can have online creditors meetings and even go to online court hearings that can save some time and cost. And then that's also a way to handle a larger amount of one-hour proceedings. I will give the floor to my panelist.
Hi, Shuai. So I think I agree with everything that you mentioned. Just to share one observation from the Singapore perspective was that we had forecast that bankruptcies and corporate insolvencies would go up seriously in a significant way because of the pandemic. But so far that has not borne out, even though some of the government measures have been tapered. What we found in the number of filings is actually that it's dropped compared to previous years. So while from the academic and the conceptual perspective, it seems that yes, it should be going up, but for some reason, just an observation that in Singapore, the numbers haven't seen that sharp uptick yet.
Yeah, I think there's no further comments from my side. Yeah.
So from Japan, our court is definitely able to handle the increase of insolvency and bankruptcy cases, because we already experienced such increase after economic bubble burst in 1990s.
Okay, thank you. I hope we have answered Steve's question. And then we'll go to the last 3 questions, and we all have 5 minutes left. And there's a question about the different roles for IPs and wind-up proceedings of SMEs. I remember Harold mentioned that the reforms in Singapore has something to do with IPs. Could you elaborate on this issue?
Yeah, thanks, Shuai. So essentially how the Singapore program is structured is that a public official, the official receiver, administers this simplified process, and then they will appoint private practitioners. And these private practitioners, unlike normal insolvency practitioners, it's envisaged they have a slightly larger role, a more facilitative and mediation role, and also to assist the debtors go through the process, like what you mentioned in your one thing that you could change in China. So a bit more hands-on in that sense, given the difficulties on navigating the system. So I think that's one of the key changes that we have in Singapore in designing the simplified process, to have someone that sort of walks beside the debtor in trying to push through the proceeding.
Yeah, if no comments from Wes and Yuri, I will go to the next question and technologies. I have mentioned during the previous part that there are some technologies that are used in China. I think maybe also in other jurisdictions like West.
Yeah, well, I think 2020 was definitely an accelerator when it comes to technologies. 2 things come to mind in terms of what I've observed in South Africa. The first one is that there's been obviously an increase in online networking, has made networking a lot easier. Therefore, finding advice and the required skills has become a lot more easier in South Africa. A number of nonprofits set up websites where people could offer to assist SMEs in distress, and so they could access free advice quite easily, and I think those networks have assisted quite a lot. Another aspect of technology has also been in the case of filing for liquidation and business rescue. That is all shifted online now, so that's been a great innovation in that respect, and it has sped that entire process up. It should have taken place a long time ago, but people got forced to do it now because of the pandemic, and I think that's been a great innovation.
I heard that also something happened in Singapore.
Hi, Shuai, thanks. So I think similar to what Wesley had said, the same acceleration and shift has happened in Singapore, and because of the success of these hybrid mechanisms, new permanent features are being put in place. And for one, in a new bill that has been just passed in Parliament, this allows for court proceedings to be done, continue to be done in a hybrid fashion. So this will also apply to insolvency proceedings. So I think that the whole digitalization sort of move is up and coming, and this will hopefully allow proceedings to be streamlined and also bring down the time and costs, particularly for SME proceedings.
Thank you very much. And our last question goes to the attorney matters for one of the SMEs. I remember Yuri mentioned Japan's conciliation, special conciliation arrangement. Could you elaborate a little bit on that issue?
Yes, so as I introduced, we have alternative measures, including the special conciliation arrangement and also the workout program under the sorry, I forget the name of the institution. but some like a workout program. So yeah, we implemented several alternative measures. So I would like to know in other jurisdictions, do you have such measures?
Not from our jurisdiction, but how about South Africa and Singapore?
No, unfortunately, other than just finding a rock to hide under, there's nothing formally.
Detail.
Thank you all. I think we are approaching the end of our panel, and I do not see additional question, and time is up. So thank you all. I hope you enjoyed our panel, and if you have other questions, just free to contact us. And look forward to see you next time.
Yeah, see you next
Thank
time.
you. Bye. See you.
Bye.
Thank you,
Thank
guys.
you very much.